Welcome to JMW's Inside Man YouTube channel. My guest is Ben Woodall. Ben is a trainee solicitor within JMW Solicitors Employment Law Team. So Ben, I know there's been a recent court decision around agency workers being brought in when other workers are on strike. Can you give me an overview of what's happened, please, and explain what the court said?
Yeah, that's right, Dominic. On Thursday, the 13th of July, the High Court ordered the quashing of regulations that had been introduced in 2020, which had allowed for workers on strike to be replaced by agency staff. Just in terms of a little bit of background, if we look back to June 2022, amidst a backdrop of industrial action in the rail industry and also strikes across other sectors, the government revoked what was known as Regulation 7 of the Conduct Regulations, which prohibited employment businesses from supplying workers to cover those undertaking official strike action or to cover workers who have been assigned to cover those on strike. The new regulations, as I've already mentioned, allow businesses to replace striking workers with agency staff. And obviously that was a significant and quite controversial change. And subsequently, 13 trade union bodies collectively brought a judicial review challenge against the regulations at the High Court.
And I suppose as workers go, if workers are on strike and businesses can bring in agency workers, it was a patch perhaps for businesses. So what would employers do going forward now?
Well, going forward, the impact of the decision is that the law reverts to its previous position. And once again, it's an offence under the conduct regulations to supply agency workers to cover those undertaking official industrial action or provide cover to workers who are covering those on strike. So I think the key takeaway in light of the High Court's decision is that those who supply agency workers should exercise extreme caution. And essentially here at JMW, we're willing to work alongside and provide support to employers in understanding the ramifications of the High Court's decision and how it impacts specifically upon their business.
And I'm glad you've said that, because there will be employers scratching their head thinking, well, what do we do? How do we navigate? How can you and the employment law team at JMW help?
Well, we're willing to listen to all queries that an employer has in light of the High Court's judgment, whether that's an ad hoc query, whether it's something quite niche, or whether it's just general questions about how the judgment impacts their business. Obviously, we're more than happy for you to get in contact with us, and we're willing to discuss the impact of the decision with employers further to help them and their businesses move forward.
Ben, thank you very much for your insight. And if you'd like to contact Ben and the employment law team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.